before we start anything, please do let me know what is your requirement, what you actually looking for. Any one of you, please? Better you keep it like that.
Yes, sir.
You've got this habit, you know.
Yes, sir.
Any one of you? What are you looking for actually?
Actually, the legal aid will be recently that, so the laborers will be coming to us.
The laborers,
Minimum wages and
compensation, etc.
mostly those things will come to us for legal aid.
So basically what I feel like you people looking for that, what kind of, cooperation and the help can be extended towards the workers.
And sir, I'm sorry to interrupt, sir. And sir, who all come under the industrial worker? Because sir, under the section 12 of Legal Service Authorities Act, we can provide free legal aid to an industrial worker. So we also need to know that who all can come under industrial workers.
So if you think from that point of view, there are a number of discussions I feel are important for us. See, whenever we are talking about this, labor protection, so the whole gamut of labor law comes into picture, and the basic jurisprudence of labor law is to extend that help towards the laborers, the workers. Now, why I'm saying that the basic purpose of the labor law is to extend the help? Because if you can understand one very important aspect of these labor relations, we all know, like whenever we are talking about these laborers, workers, there is one other side of this group, that is the employer of the management. So there is no existence of workers or the laborers without the management and the employer. So until and unless you know that particular equation properly, you understand that equation, you understand that basic jurisprudence of that equation, you cannot get acquainted with the different laws which are existing for extending the help towards that community. If I intend to work somewhere, I must know a basic philosophy, basic jurisprudence of that area. Otherwise, what I feel, you won't be able to acquaint yourself with that area of field or anything whatever. Today you have come here just to get some basic information that what kind of help at what juncture, like what kind of help we can extend. These all things are the basic requirements, right? Now I tell you, before you proceed, before you make up your mind that okay, I need to help this worker, I need to help that worker. And see, we can't ignore that whenever we are talking about some kind of help to be extended towards the workers, the other group, that is the management, comes into picture. All of you getting my point?
Yes, sir.
Now I tell you one very important aspect, because see, I am emphasizing on one particular point. Until and unless you get acquainted with the jurisprudence of this labor management relationship, you cannot exercise your mind, you cannot apply your mind. So, okay, I need to extend this type of help. Now whenever we are talking about that any sort of help, any kind of help to be extended, remember, we can provide the help or the assistance with the help of the laws only. You can't deny. And let me tell you, whenever we are talking about the whole relationship of the management and the laborers, we have around 45 central legislations which are governing the rights of the workers from different perspectives. And if we are talking about the state legislations, we have around more than 60 state legislations or 70 or 80 state legislations, which are talking about the different kind of assistance or the help which you can extend towards the workers. That is what I am saying. That whenever this idea comes in your mind, because you are now getting associated with this, paralegal volunteer training program. That means what we are expecting that you go to the field. It's not like a classroom teaching that I will deal with the definition of the workman. It's not required. Whosoever comes to you as a workman, you need to know what are the laws which are existing. What is the basic purpose of that law? I tell you one more important point what I feel. Without knowing the basic purpose of the law, you cannot, apply that law. It's not like, closing your mind and eyes, etc. and you are applying something. Okay, you are entitled for this one. You need to know basic fields, okay? And that is what I am saying. This labor management relationship is a unique relationship where if you have a look at this relationship, both the parties would try to maximize their benefit. Again, you please understand first. Then we can think over that what kind of assistance, what kind of help can be expected. Now this is a unique relationship. Why I am saying such? Because see, the management would always try to maximize the benefit. But when the management would try to maximize the benefit, the management cannot ignore the labor force or the workforce. You getting? All of you are attending this lecture. After the lecture gets over, if I ask you, you give me the summary of this lecture, and if I ask her, the quality will differ. It will differ in quantity wise as well. You know why? Because ultimately it depends how you are using your skill. That is what this labor protection, workers protection, the protection of the workers coming to the picture is so important. Because the management would always try to maximize the benefit. There is no denying of this fact. But management cannot ignore the force, that workforce. You know why? Because after they use their skill, the production matters. The production varies. You install same machine in two different companies. Okay? Same raw materials. Still, end of the day pay, what you might come across, there is a variation as far as the quality of the production is concerned. Because ultimately, end of the day pay, this is the utilization of the labor resource, their skills. And that is what I am telling you before we deal all those points that what all protections, general protections are there. Please to understand this basic philosophy of labor management relation, where both the parties will try to maximize their benefit, but management at the end of the day cannot ignore this labor workforce. And the workers will give their skills, everything, and in return they would expect some kind of social security. You give us security, we are giving our labor, we are giving our toil, we are giving our blood, everything. If I cannot sleep properly, tomorrow you can't expect my efficiency level at a higher level. If I do not have that basic minimum requirements of a dignified life, you cannot expect that I will be giving or my skill would be utilized to the highest level. Can you expect? You can't expect. And this is this dynamic relationship. You understanding my point? I would be expecting maximize benefit out of the resources which I am having. But if I don't give you that protection, that security, all of you getting my point? I can't expect that you will be giving your 100%, or I can't even expect that your skills will be used to the 100%, to the extent of 100%. I cannot expect. And that is what this protection now comes into picture. I have no other option. I have to maximize my benefit. And in the whole process, when you are giving your skill, right? When you are putting your labor, your toil, your blood, everything, your sweat, in return, you are expecting something. That expectation is very minimum expectation. You give us some security. Now this security is not in terms of the employment only. This is in terms of your social security from different aspect. It's not like you give me a air-conditioned room in my place of employment. It's not the protection. It's not the expectation. They expect that if I die during the course of my employment, there should be some provision so that the management gives some compensation to my dependents. If I suffer some injury out of my course of employment, the management should be giving something so that I can sustain my life. These are the protections. These basic minimum protections in the form of the social security. And that is what we all are, looking for, that we will be part of this, paralegal volunteer training. We will be part of that, committee, and we will be, serving this society. Serving this society, but not the whole society we are now talking about. We are talking about that element of the society, which requires that social security, which requires that protection. And now you know why they require it, and how much important their requirement is. Because if you can't provide them social security, if you can't provide them all those minimum basic protections, you can't expect that they would give their toil, blood, etc., for maximizing the benefit of your life. All of you getting that? So now we are centralizing our discussion, keeping in mind this thing, that this group which we are talking about, that is working people, the laborers, the workers, they need a protection. They need a protection for certain reasons which you cannot avoid. The employer should give that protection for the maximum benefit of an enterprise only. All of you understanding? And now we should deal, as I told you, whenever we are talking about the kind of protection we need to afford to the workers, we cannot go without the existing laws. And until and unless you come to know the very jurisprudence of the laws which are existing, now you have little bit you have come to know what is the basic purpose of dealing different laws which are existing there. All of you getting that point? So let us have a look. So as I told you, there are around 30-40 central legislations. Number of central legislations are there, state legislations are there. All legislations are meant to afford the protection to the workers in terms of their social security, in terms of their welfare legislations, some welfare activities for the workers, etc., etc. So now let's have a look. What are the general protections now we are talking about? When we are talking about this social security, obviously we are looking for this thing, right? We are looking for this thing, that how to protect these workers so that they are not deprived of their basic rights of getting the social security. Okay? First legislation which will come into picture is the Employees Compensation Act 1923. Every day, everywhere, in every industrial undertaking, wherever you go, you would come across at least 10% of the total cases which are pending in that industrial undertaking in relation to the compensation which is being claimed by the workman or his dependents in case of certain injuries or death of the workman. So as a member of this, organization, you need to know the basic law that whenever any worker does receive any injury out of any accident which is taking place in the course of the employment, what is this law which is talking about the giving of any kind of compensation in any form towards those workers who have either received any disablement in the form of the permanent disablement, partial disablement, total disablement, etc. etc. Right? So tomorrow one might come up, say to 1 year back, I received one injury and I cannot perform the function which I was allocated. So I have been terminated from the service and I have not been given any compensation. You might come across these cases. These are happening every day. All of you getting my point? Or else you might come across like one widow is coming and saying that my husband died because of one accident in the place of the employment and I have not been given any compensation. So these are the very normal cases which you will come across every day whenever we are talking about this labor protection, etc. etc. Protection of the rights of the laborers, protection of the rights of the workers. So whenever we are talking about the protection of the rights of the workers, protection of the rights of the laborers, etc. etc. This grunting compensation forms a very important part of the social security protection towards the workers. So all of you getting it? So now let's have a look about the social security in the form of the compensation. Right? You must know that whenever in India we are talking about the social security of the workers in case of their death or any injury in the form of the compensation, in India there are two different schemes which are applicable for this area, that is grunting compensation. So whenever we are talking about this compensatory jurisprudence of the social security concept, all of you getting the point? So whenever we are talking about this compensatory jurisprudence of the social security component, right? So please try to understand. The umbrella head is the protection of the workers we are talking about, right? One of the components is in the form of the social security. Now social security ki form hai, in this form, now we are talking about the compensatory jurisprudence. What jurisprudence is lying in India as far as the compensation is concerned? Compensation to whom? The workmen who either died or who got any injury in the place of the employment. This will happen everywhere in every industrial undertaking. Right? Now whenever we are talking about compensatory jurisprudence, we in India we have two different schemes available, right? One is compensatory scheme in the form of the assistance, and the other one is compensatory scheme in the form of the insurance. Okay? Now we have two basic legislations in India, because see, whenever you are going to deal any particular problem of any worker, you need to understand that which compensatory scheme is applicable to him. Then only you can suggest. For one particular employee, if Workmen Compensation Act 1923 is not applicable, you cannot suggest him you go to Compensation Commission. You need to understand. That's what I'm making you clear. In the whole compensatory jurisprudence in India, when we are talking about the compensatory jurisprudence, one is assistance scheme में होते हैं, the other one is the insurance scheme में. Assistance scheme के लिए जो legislation हमारे इंडिया में है, that is the Workmen Compensation Act 1923, जो 2009 की amendment के बाद the nomenclature is changed. That is the employees exactly Compensation Act 1923. और अगर कोई इंश्योरेंस स्कीम में कोई कंपेंसेशन दिए जा रहा है, you getting my point? If there is any compensatory scheme in the form of the insurance, for that the legislation which we have is the Employees State Insurance Act 1948. Now these two legislations are carrying two different schemes. First one, the Employees Compensation Act 1923, is the assistance scheme. This is always the bipartite, contribution, right? And when we are talking about the insurance scheme, this is the tripartite, contribution. I did it very, not to make the matter more complicated, because you just need to know the basic idea of these laws. Jab Mano, this is an undertaking, okay? I mean, this is optional. You must understand all this. This is optional. Either though in your undertaking, the Employees Compensation Act 1923 is applicable, or in your undertaking, Employees State Insurance Act 1948 is applicable. Now, this Employees State Insurance Act 1948, the central government has given this direction that all industrial undertaking must, adopt this scheme. This is insurance for me. You know that concept of insurance. You pay something, the employer would pay something, and in your, untoward incident or event in your life, the insurance would give a huge amount of compensation. That means there is tripartite contribution. All of you getting? And assistance scheme is not tripartite contribution. It's a bipartite contribution. In a sense that the employer would pay from his own pocket. So if tomorrow you receive an injury and your undertaking is being governed by the Compensation Act 1923, there the employer would not give any compensation out of the insurance scheme. The employer would give from his own pocket. And that is what, in those undertakings where your assistance scheme is available, I mean workmen compensation, the amount of compensation is much less than the amount of compensation which you usually get under the insurance scheme. So this is clear to all of you that we are having two schemes. One is assistance, the other one is insurance. Assistance के लिए जो act है, that is Employees Compensation Act 1923, right? And insurance के लिए Employees State Insurance Act 1948. This is a tripartite contribution. We are not doing all these things. क्या mechanism है इसकी? It's not required. Okay? So let's have a look. What is there in Employees Compensation Act 1923? Because the paper which was given to me, I came across that this legislation was referred, that Workmen Compensation Act. So you referred three legislations, right? If I remember correctly. One is Workmen Compensation, the second one is Minimum Wages Act, and the third one is Contract Labor Regulation and Abolition Act.
Yes.
So now we are starting the discussion on the Employees Compensation Act 1920. So before that, everything is clear? No confusion? So you know now the jurisprudence, the making of this, the Employees Compensation Act 1923, the context in which this is to be implemented, etc., right? Employees Compensation Act 1923 is a very important piece of social legislation, definitely. Now we will highlight this legislation because this was being referred there. Okay. Now Employees Compensation Act 1923 talks about 4 different circumstances when the employee or the workman who would come to you is entitled to get compensation. All of you getting? Okay? So you must ensure that whether the employee or the workman who has come to you has received either of the injuries referred here. Now for death, first situation is death, there is no question. He will not come, definitely. His dependents should come. So for death, I mean these are statutory provisions, so you can argue that he is entitled to get the compensation. And it's almost like, strict liability principle we follow it. Yeah, you getting my point? No fault liability. Even if even if there is no fault on the side of the employer, if you receive any injury in the course of the employment, out of the employment, that I will explain you. All of you getting my point? The employer will be liable to pay you the compensation. So if at all you come across that the employer is contending to you when you are approaching to the employer that he has received this injury and that is what he is entitled to get compensation. If at all the employer is contending, no, I was not liable, so you can put this plea that this is a statutory liability, it's almost like no fault liability. So if any of the workmen or the employee working over there has received any of the injuries referred here, he is entitled to get the compensation, irrespective of the matter whether the employer was at fault or not, provided that the accident must have occurred within and out of the course of the employment. That has a different connotation for that expression. We are not dealing that part. But for the initial understanding, now the four situations we are talking about, one is death. Right? The second one is the permanent total disablement. Right? The third one is permanent partial disablement. Okay? And the fourth one is temporary disablement. Done? The Act says that for death, okay, if any worker dies in the course of the employment, all of you getting my point? Is entitled to get a compensation of 50% of his basic wage multiplied by the relevant factor, or 1,20,000, whichever is more.
Sir, could you please put the quantum of compensation?
This is the quantum of the compensation that if any person dies in the course of the employment, is entitled to get compensation of 50% of his basic wage multiplied by the relevant factor. Now you don't know what is relevant factor, right? I will let you know later on. So this is one component, or the other component is or 1,20,000, whichever is more. For the permanent total disablement, this is the 60% of your basic wage multiplied by the relevant factor, or 1,40,000, whichever is more. For the permanent partial disablement, now for the permanent partial disablement, what happened? Okay. 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 Now for death it's clear. For permanent total disablement it's clear. For permanent partial disablement, you need to understand what is this permanent partial disablement. Okay? For that you must refer, you must know all these basic ideas. The Act does contain so many schedules. Okay? In Schedule 1 of this Act, there are two parts, Part 1 and Part 2. Part 1 contains 6 injuries. Now if you receive either of the injuries mentioned in Part 1 of Schedule 1, that would always be termed as permanent total disablement. Getting my point? So you need to just, verify if somebody is coming to you that he has received this injury. Now what is there? If you have a look at the schedule of this part. Yes. See, just have a look. You'll find it obviously. It's in the legislation only. It's in the Bare Act only. Part 1 does contain 6 injuries. Now, if you receive any of the injuries, then your disablement is permanent total disablement. So you can argue with the employer that what would be the amount of the compensation when you know everything, the basic point. So permanent total disablement के लिए आपकी compensation क्या होना चाहिए? या तो 60% of your basic wage multiplied by the relevant factor or 1,40,000, whichever is more. Death के लिए is 50% of your basic wage multiplied by the relevant factor or 1,20,000, whichever is more. Permanent partial, just write it out 2, 3. जैसे I'm talking about, listen, I mean थोड़ा सा complicated हो सकते हैं. I mean